distinguished lady senator and now international jurist.
Proceed.
Mr. President, point of order. He will engage in a colloquy with me, a judge. The judge has spoken. Now the judge is taking time to deliberate on what she has just told the court. I don't think this is proper.
Counsel-
You should debate among yourselves. You do not debate with a judge.
Yeah, Counsel, I'm sorry. A member of the court objects to any further discussion. So
Yes, sir.
I will make a ruling.
Mr. President, may I just add for 2 minutes a remark? Well, one of the exceptions to the hearsay rule, one of the 11 exceptions to the hearsay rule under Rule 130 is Section 44.
And which says?
Yes, let me read that. Yeah. It says, Section 44 of Rule 130, one of the 11 exceptions to the hearsay rule. And it says, quote, entries in official records. Entries in official records made in the performance of his duty by a public officer of the Philippines or by a person in the performance of a duty especially enjoined by law are prima facie evidence of the facts therein stated. This is an exception
Yes.
to the hearsay rule, and therefore the burden of persuasion is shifted. We have exercised our burden.
Mr.
because it's
President.
one- Then the burden is shifted to the defense to demonstrate to the
May I
court
beg the
that we do
indulgence
not
of
fall
the
within
lady
this
senator
exception.
from
Yeah.
Iloilo to let the counsel finish and then I will recognize her.
Thank you.
Yes. Proceed.
Yes, I'm finished with my statement.
That does not apply, counsel. Let me educate you. When an official custodian or other representative qualified by that office or authorized by that office to issue an official record does so, then the presumption applies that what is stated in the official record is correct. To that extent, therefore, there is an exception to the hearsay rule. That person or that custodian or that record keeper does not have to explain why his record is that way. You just have to take it on faith. That is the meaning of that. But we are talking of a dissenting opinion by collegiate body, the Supreme Court. So, if the dissenting opinion contains certain narrations of fact, which in fact are intended to dispute what the majority opinion has issued, you cannot prima facie presume that the dissenting opinion is correct and the majority opinion is wrong. That's why I read you those cases where the Supreme Court repeatedly said, you rely on the majority opinion, not on the dissenting opinion. That is why I was warning you already, do not engage in a colloquy with the judge. That is not allowed by the rules of the impeachment court.
All right.
Put it in your memorandum.
All right. May the presiding officer now make a ruling? Is there any objection? All right. It is the ruling of the chair that to the extent of the facts narrated by the witness on the basis of the dissenting opinion, let them remain as a part of her testimony. Let them remain as a part of the record as a consequence and part of her testimony here as a witness. But to the extent of the truth or falsity of what the dissenting opinion of Justice Sereno contain, to the extent of those facts, whether they're true or not, that the Chief Justice influenced this or the Chief Justice did that or somebody else did something else, then to that extent it is hearsay because the witness was not present when those things were being done or being said. And so I will allow the testimony of the witness to remain into the record and admonish, or rather suggest to the court to disregard whether the statement of the Chief Justice or what he did or other justices did in the course of their deliberation, because those are not within the competence of the witness to testify on, so therefore those are hearsay.
Thank you, Your Honor. I was about to make a short manifestation, Your Honor, as to the effect of a declaration or statement being considered as hearsay.
Yes.
Because there are plenty of jurisprudence to the effect that whether objected to or not, if the testimony is hearsay, it shall not and must not be considered by the court in rendering a decision, Your Honor.
Yes, but we must remember that we are not trying a criminal case. We're trying an impeachment case. Although there is a penalty, the only penalty is not loss of freedom or infliction of an economic burden, but the removal of the respondent from his position and his disqualification. And therefore, the principle of the rule on hearsay, the hearsay rule contained in our rules of evidence, do not apply strictly in impeachment cases, as far as I could remember what I read about the experience of the United States in impeachment cases. It's true that in a strictly criminal case, the hearsay rule is a very strictly adhered to as a rule of evidence, but not in an impeachment case. And that's why I made the distinction between the truth or falsity of what was related by Justice Sereno in her dissenting opinion and what the witness now said based on what was contained or the information being presented to her on the basis of the dissenting opinion of Justice Sereno. To that extent, and to the extent of the dissenting opinion, let it stay as a part of the testimony of the witness. So ordered.
Now, I